It's time for another installment of Martial Law. This program intended to be for informational purposes only. The information does not constitute legal advice. The law is constantly changing. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. And because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. One of those guys is Marshall Chriswell. Good morning.
Good morning.
Good to have you with us here today. So we want to talk this morning we've been talking about estate law recently, and I want to continue that conversation by visiting the topic of contested wills. Now, that's a term that we hear a lot. What does it mean?
Sure. Contesting a will generally refers to a situation where someone has passed away, and an individual or group of individuals who are close relatives or otherwise have legal standing to do so decide, we don't think that the will that's been proposed or that's been admitted to probate, we don't think that that will is valid for some reason. And there are lots of reasons that you can contest a will, but something to know at the outset is that something I always tell folks when they come in and we have a consultation about potentially contesting someone's will is that it's under Pennsylvania law, it's a difficult thing to do. There is not a high probability of success. You can win if you have the right facts and the law on your side, but it's an uphill battle.
Well, yeah, one would think that it would need to be. That's the way the system is designed, and it obviously is to preserve the best wishes of the person whose property is being passed along. What would be some of those scenarios that would maybe lean toward making it a successful contesting of a will?
Sure. So to prove that a will is invalid, you're going to have to prove, and most of these things have to be proved by what we call clear and convincing evidence, which is the highest legal standard under civil law. It's when you talk about criminal law, you always hear beyond a reasonable doubt, right? That's the highest standard in the law. In civil law, clear and convincing evidence is the highest standard, and so you've got to prove this, with solid evidence. And so some of the reasons you can contest a will, one would be that the person did not have testamentary capacity. They mentally were of a weakened intellect, in a weakened state, and did not have the ability to understand the documents they were signing. Didn't understand couldn't have understood what their assets were and how they wanted to plan for their distribution. And again, you've got to prove this by clear and convincing evidence.
I would think that one of the more common cases in this instance would be children, where there is a second spouse involved, or split families, blended families with children from different marriages coming in. All of those sorts of things. But it can't just be, I don't like what I got and I like what that person over there got better. It has to be really, really much more than that.
Absolutely. And when we're talking about, contesting a will for the lack of capacity, if someone didn't have the mental capacity to sign the document, it's not good enough to just say, well, Mom really, she wasn't, she was sick and she wasn't really understanding things. I have a lot of clients that come in and say these things, right? They say, well, Mom was old and she just didn't understand things. She got confused sometimes, and so this will. There's no way that this will could have been valid because it was signed toward the end of her life. No, we need generally expert testimony from doctors saying that from Mom's doctor saying that she was unable to understand what she was signing. You need witnesses from the day of or around the day that Mom signed the will as to what her mental state was like. You need to really line up your evidence, and just saying, Mom got confused sometimes, it isn't going to do it.
Could this be a part of it as well? A will is made out maybe a decade or so in advance of the death. Meanwhile, there's been a secondary acquisition of property, or say they've come into money, or whatever it happens to be. There's other property that isn't covered in the actual will, and therefore they can allow what happens within the will to happen and still have a chance at a contested will for that property that isn't specifically delineated?
Well, most wills are going to include a residuary clause. Any will that I draft, and any good estate plan practitioner is going to include a provision there that says, okay, here are we've got all these specific things, maybe whether it's real estate or personal property or bank accounts or cash, that are delineated. And then there's a provision which says, okay, and all the rest, residue, and remainder of my estate, everything else that I own is going to go to X, Y, and Z, whether it's in percentages to different individuals or charities or what have you. But there's a provision in there, a catch-all provision. So normally, after acquired assets, something or anything that isn't specifically listed in the will is going to fall under that residuary clause. Now, that being said, when you acquire significant additional assets during your life, often this is later in life, maybe you inherit from your parents or from other family members, and you acquire additional assets. It is a very good idea to update your will at that time, so that you don't run into these kinds of conflicts later on. So it can be the root of conflict, but often there's language in the will to take care of it.
But that's one provision that an attorney will put in ahead of time to make sure that everything is covered. I'm sure there are things people can do to sort of forestall or prevent any sort of contesting of their will, and that probably is as much a big part of what you do as anything, right?
Absolutely. I think one of the things, and I've talked about it previously in other segments we've done, is one of the things is transparency. Talking to your kids or other beneficiaries under your will, and letting them know what you've done. Because when the time comes that someone opens up this will and reads it after you're gone, so many questions can arise as to why the person decided to have their assets distributed in the way that they've set forth. And at that point, it's too late, of course, to go back and say, Mom, Dad, Uncle Jim, why'd you do it this way? So the transparency I think is really important. Having clearly written estate planning documents is another thing. I have run across a lot of wills and trusts and things that the language gets fuzzy, and a lot of times that reflects the fact that the client, the person, was maybe having some difficulty deciding how they wanted to do things, and hedging on things, and that's very common. But having clearly written estate plan documents is another thing that can go a long way towards staving off conflict.
And when you have those discussions with the people who are preparing the will, obviously you would say, that's not my responsibility to explain to anybody. If you want me to, then they can come in. You can have them come in and visit with me. But this is the responsibility of the person who is making out that will. It's their wishes, and they need to make sure that everybody in their circle who will be involved understands what's happening and going on.
Yeah. And at the very least, having a conversation with the person that you're appointing as the executor or trustee, or even your power of attorney agents, having conversations with them to make sure that they understand what your wishes are. And certainly, if the client wants to have those individuals come in and meet with me at in one meeting, as long as the client consents to that, because obviously there's confidential information there. But we can do that. We can have the kids come in and sit in on a meeting, and everybody can talk through it. And I think that's really, really helpful sometimes.
Contesting of the will, our topic with attorney Marshall Chriswell this morning. Couple of moments left with him. Let's get back to the actual contesting of the will. How does that happen? Do they come to you and then you take the case into court? Line that all out for me.
Sure. Yeah. Obviously, it starts with a meeting, with a consultation, and this is going to be a very detailed conversation about why you believe the will to be invalid, what grounds there may be. I've got to make sure, okay, are these folks that have standing to contest the will? Like I said, you either need to be a close relative that would have inherited under law but for the will, or someone who was a beneficiary in a prior will. You have to have been you have to be what the law calls an aggrieved party. So we've got to make sure you have standing. And then if we determine, okay, you've got standing to contest, and the facts seem good, then you move forward. And if we end up filing, you do it one of two ways. You file either if the will has not been probated yet. Sometimes you get wind of what the will has in it, but the executor hasn't probated it yet. You can file an appeal prior to the probate. That's called a caveat, and you file that with the Register of Wills office, basically saying, please don't admit this will to probate if someone attempts to probate it, because we believe it to be invalid, or if the will has already been admitted to probate, then we file an appeal to what's called the Orphans Court, which is a division of the Court of Common Pleas, the county court, and you file that an appeal under Section 908 of the Probate Code, and you have to do that within 1 year of the date that the will was probated. So you've got a 1 year statute of limitations to file that probate appeal. So that's the procedure. And then once you file it, assuming the other side comes back and says nope, the will's valid, and they want to proceed to a trial, you go through just like any other civil trial. You go through a process of discovery where you exchange information and documents, and you can depose witnesses and things, ultimately with the goal of getting to a civil trial where a judge is going to decide if you've got enough evidence to overturn this will.
Okay, so that's a very involved process. You need your competent attorney to help you through it. Marshall, if somebody wants to hire you on for that, what should they do?
You can call me at 724-465-5826. Stop and see us in the R&P Cole building, which is 655 Church Street in Indiana, or go online to www.westernpalawyer.com.
Thanks, sir.
.com.
Thanks, sir.
.com.